Good afternoon. Welcome to this talk by the Center for Comparative and Public Law. We're extremely honored today to have Professor Niels Petersen with us to talk about his book, Proportionality and Judicial Activism, Fundamental Rights Adjudication in Canada, Germany, and South Africa, published by Cambridge University Press earlier this year. Congratulations on the publication of this important thesis. Critics of proportionality often argue that proportionality is a tool for judicial activism. In this book, Niels tests this assumption empirically and does it very systematically. He develops an original framework of analysis for testing whether proportionality is indeed a tool for judicial activism. And that framework, I think, you applied it to Canada, Germany, and South Africa, but it will be applicable broadly to any common law, not just common law, not any jurisdiction that applies the four-limb proportionality test, I think. So we're very eager to hear from Niels what that framework of analysis is and what his findings are. Most of us in this room should be familiar with Professor Petersen's works, but I'll just very briefly introduce Niels for those who are not familiar with Professor Petersen. Professor Niels Petersen is Professor of Public Law, International Law, and EU Law at the University of Münster since February 2015. This fall, he is a visiting professor at the University of Auckland. He holds a PhD in law from Goethe University in Frankfurt and an MA in quantitative methods in the social sciences from Columbia University. From 2004 to 2006, he was a research fellow at the Max Planck Institute for Research on Collective Goods in Heidelberg. As a postdoc, he worked as a senior research fellow at the Max Planck Institute for Research on Collective Goods in Bonn from 2007 to 2015. He was also a visiting doctoral researcher and a Holzer research scholar at the New York University School of Law. His research focuses on comparative constitutional law, human rights law, the sources of public international law, as well as the economic analysis of law. Let's welcome Professor Niels Petersen.
Thank you so much. Thank you so much, Cara, for the invitation to come here. I'm very excited to be in Hong Kong, and I'm always excited, of course, to talk about my book. And as Cara already pointed out in the beginning, the original question that I was asking for this book was whether proportionality actually promotes judicial activism. There's a big theoretical discussion on the rationality of proportionality. So some people say that, especially the last step of proportionality, the balancing between the individual right and the public purpose, that this is irrational because we are comparing incommensurable values and, for example, security against liberty, or in abortion cases, the right of the unborn life against the freedom of self-determination of the woman, or so many cases where we have proportionality balancing involve a comparison of incommensurable values. And there's something to this critique. And now the second critique that's basically adding on this first critique, because the last step of the proportionality test is problematic, courts use it as a tool to extend their own judicial power and to hide masked political decision-making behind proportionality. And that's basically the critique that I'm addressing in my book. And first, I look at the incommensurability critique. So, is balancing really irrational? And there, my result is that, well, it's true that that the balancing test, the balancing stage of the test, requires a comparison of incommensurable values. However, this doesn't mean that that it's irrational. Judges always have a certain amount of discretion in their decision making. There's never a judicial decision that's totally determined by legal norms. They have to interpret legal norms. And for this reason, that they are comparing incommensurable values only means that decisions are not totally determined by the proportionality test, that judges have a certain amount of discretion. And now the question is this discretion so large that judges indeed use it for judicial activism? What did I do in this book? I looked at 3 different jurisdictions, Germany, Canada, South Africa. Why these 3 jurisdictions? Basically, 2 reasons for it. The first one is I wanted to have a rather long history of proportionality jurisprudence. So if you only have a few decisions, it's very difficult to draw more abstract conclusions from these decisions. And for at least national constitutional courts, probably Canada, Germany, and South Africa are the 3 courts that apply the proportionality test for the longest period of time. Secondly, it's also fits nicely that they come from different legal traditions. So Germany is a civil law country, Canada is a common law country, South Africa is somewhere in between, very much influenced by common law, but has also some Roman law elements. And so the question that I could also answer to a certain extent is maybe whether courts use it as a tool of judicial activism might also vary across different legal traditions. This is a second reason why I chose these 3 courts. And then what did I do exactly in my analysis? I looked basically at all decisions where courts declared a statute, a legislative act, inconsistent with an individual right of the Constitution. Why only decisions where it declared laws inconsistent with the Constitution? Because I thought that here the conflict of judges reaching out into the political sphere is greatest, where judges basically say, stop to the legislature, you can't go this far because it's inconsistent with the Constitution at this point. In other decisions, when they confirm a legislative decision, that might also be politically, it might also be a highly political decision, but they are on the side of the legislature, so they can't really be accused of interfering with the decision-making space of the legislature. And when they control lower court decisions, which were controlling executive decisions, or sometimes even decisions that were taken by criminal courts or by civil courts, then you usually have then they interfere with the competencies of other courts or with the executive. So the conflict is not quite as stark as the conflict with the legislature. Of course, it was also a pragmatic decision. If you look at all decisions of all 3 courts, then you're never finished. So here I had about 400 to 500 decisions of the 3 courts in total I had to look at. This is still manageable. If you look at, 5,000 decisions, that wouldn't be manageable. Anymore. Now, I first started with a theoretical prediction. So, why should it be that courts act in an activist manner when they apply proportionality, and maybe it's even the other way around? So often it's said that courts basically are the last guardians of the Constitution, and that there's only the blue sky. It's a German expression. Courts only have the blue sky above them, so there's no authority above courts which could overturn a judicial decision. So basically, they can decide as they want without having any instance that controls them. So that's usually one of the critiques that's voiced against judicial powers. However, if we look more closely, then this is probably a bit short-sighted, this critique, because courts are not totally independent of the executive or the legislative branch. Why not? Because courts neither have a purse nor a sword, so they can't implement their own decisions, and their own competencies also depend on the legislature. So basically, if the legislature isn't happy with a decision by a constitutional court, it could just not comply with this decision. So enact a law that's similar to the one that they have enacted, or depending on what the actual powers of a constitutional court are, when they can only declare a decision incompatible with or a statute incompatible with the Constitution, and the legislature has to act, and the legislature could decide not to act. So what's actually the power of courts? The power of courts is their own legitimacy, the acceptance by the general population, so that if the legislature doesn't comply with a judicial decision, that the general electorate sees this as a violation of the rules of the game, and might punish the current government for not complying with the court decision. So that's basically the main strength that constitutional courts have to exercise power against the legislature and against the executive. And now I'm hypothesizing that in order to be perceived as a legitimate actor by the general population, I mean, there are different reasons why courts might be popular. It might be because they defend individual rights and people only get something from courts, but if they lose in the constitutional court, then basically the main responsible is the legislature, not the court. But another reason for why courts are legitimate is that they at least appear to decide according to legal standards. They are perceived to be neutral arbiters which decide according to legal standards and which are not caught up in the day-to-day politicizing of the political process, which do not decide according to ideological standards. And there's some empirical research which actually shows that people want decision makers to react to, they want to have, in principle, what they want is neutral decision makers that resolve problems and don't decide according to ideological standards because they are in a certain political camp. So that's, and so if courts are perceived as neutral actors, then this enhances their own legitimacy. And how are they perceived as neutral actors? They are perceived as neutral actors when they decide according to legal standards. And this would suggest that in a doctrinal instrument that's perceived to be as problematic, like the last step of the proportionality test, balancing, might not be an ideal tool to exercise judicial activism, because that's where people are looking at anyways. So then decisions might perceive to be problematic if statutes are declared incompatible in the last step of the proportionality test. And that's why I hypothesize that courts would rather exercise self-restraint when applying the proportionality test. Now that's the theoretical hypothesis, and from there I go on and make an empirical analysis of these decisions, and it's a very modest empirical analysis. My book doesn't contain any sophisticated regression analysis, but I only categorize and then quantify, but it's descriptive statistics. It's not analytical statistics, what I'm doing. And what we see there, so what I looked at first is when courts apply proportionality, at which step of the proportionality test do they declare a law incompatible with the Constitution? Do they actually use balancing for that? And secondly, if they balance, what do they do if they balance? So are there any additional steps that they use in order to rationalize their balancing decision? And now what you can see for the Canadian Supreme Court and the South African Constitutional Court, they rarely balance. So they usually, when they declare a law inconsistent with the Constitution, then they usually rely on one of the previous steps of the proportionality test. Rarely they say that a law already lacks a legitimate aim. In the South African jurisprudence, we have some laws stemming from the apartheid era where the court says, well, these are not legitimate because they are apartheid era laws. They want to exclude blacks, so that's not a legitimate aim. But that rarely happens. Usually they use rational connection. A law is not rationally connected to the aim that it's pursuing, or less restrictive means. So there's an alternative means which is less restrictive to pursue the same aim. They usually use one of these, and usually the less restrictive means stage of the test, but rarely balancing. There are a few decisions, maybe 4 or 5 of the Canadian Supreme Court and 2 of the South African Constitutional Court where they actually declare a law inconsistent with the Constitution in the balancing stage, but that amounts to less than 10% of all cases. So it's a rather insignificant amount. Now, if we look at the German Federal Constitutional Court, at least in the last 30 years, the picture is quite different. The German Constitutional Court uses balancing, the last step of proportionality, as the main tool to declare laws inconsistent with the Constitution. So they rarely rely, they have a very narrow understanding of the rational connection step or suitability step, or however you want to call it, and they have a very narrow understanding of the less restrictive means step or necessity step. So what they say, basically, for an alternative means to be considered in the less restrictive means stage, it has to be proven that it's equally effective as the measure that was challenged, and that's basically under review. So any alternative measure has to be equally effective, and basically the burden of proof falls on the challenger, on the individual which challenges the law, and that rarely happens. So for this reason, national connection and less restrictive means stages rarely play a role, at least in the later jurisprudence of the German Federal Constitutional Court. So the court balances, and there is now some fear that maybe the balancing that the court does actually is really judicial activism, so that at least the German court is subject to this critique, and then there's a justifiable critique, at least of the German courts, if maybe not of the Canadian Supreme Court and the South African Constitutional Court. So I looked more closely at what the German court does when it's actually balancing, declaring a law inconsistent with the Constitution in the balancing stage. And what you find there is that you can basically identify 4 different groups of cases in this balancing stage, which I would interpret as exercising judicial self-restraint. What are these 4 groups of cases? First group of cases is burden shifting, shifting of financial burden. So basically, the court says, well, the legislature is pursuing a legitimate aim. However, so basically it's usually when a private actor is burdened to pursue a goal for public benefit. Then the legislature says, the court says the legislature is pursuing a legitimate aim. However, the private actor, he is acting in the public benefit, so he should in some way be compensated for acting in the public benefit. So one example is a law which asked employers to grant paid leave to employees which were performing duties in the public interest. For example, they were coaching children groups, and they could ask for 1 week of leave if they wanted to make an excursion with these children or something like that. But and here the court said, well, in principle, it's fine that these employees can ask for leave, and this doesn't count towards their normal vacation. However, it shouldn't be paid leave. It should be that basically the legislature, the public, funds these leaves because it's in the public benefit. The employer doesn't have any interest in it, so it shouldn't be paid leave, and it's too burdensome for the employer here to pay for this leave, which is basically in the public interest. The second group of cases is usually where the German court finds that there's insufficient fit between the measure and the purpose. So that there is an alternative means which might not be equally effective, but which is almost as effective as the challenged measure, but it's much less restrictive. So cases that the Canadian Supreme Court or the South African Constitutional Court would probably deal with under the less restrictive means stage, the German court doesn't deal with them under the less restrictive means stage, but the German court picks them up in the balancing stage and says, well, there is an alternative means. It's not equally effective, but considering the balance, there are other ways to pursue this goal, which are much less restrictive for individual rights. The third group is inconsistency. So here the German court basically says it's the way the legislature or the aim the legislature is pursuing is legitimate, but the whole measure is designed in a way that we have a suspicion that the legislature actually pursues some other goal than the goal that it claims to pursue. And one example here is a norm in the German Civil Procedure Code, which basically said that if people are incapacitated because of dissipation or alcoholism, then this incapacitation has to be published in some public register. And the reason that the German government was giving in defending these laws was that this is necessary for the trust of the general public into legal relations, so the general public should know who is incapacitated and for what reasons these people are incapacitated. However, if we buy this justification of the law, then this reason should apply to any causes of incapacitation, not just dissipation and alcoholism, but any other causes of incapacitation. And it turns out that dissipation and alcoholism are the cases of incapacitation are less than 10% of all cases of incapacitation. So this evokes the suspicion that something else is going on, and probably the publishing requirement rather should have a stigmatizing effect rather than protecting the trust of the general public in legal relations, because there's no sense to exclude other causes of incapacitation from this publication requirement, if that was the real reason. So this is inconsistency, and here the court says, well, the measure is disproportionate because it's inconsistent. And the final group of cases are cases of individual hardship, where the measure is usually fine in general terms. However, there's a small group on which the measure imposes a particular individual hardship, a particular burden, and for this reason, the court asked the legislature to create an exception for this group. And one example here is the repository copy decision of the German Constitutional Court, which dealt with a regional law in Germany, where a specific region asked every publisher that was publishing a book in this region to provide a free copy of this book to the public state library, so that any person in the state has access to any book that's published in this region. And here the court said, well, this is in principle a legitimate aim. It's also in principle proportionate. And it's totally fine if a novel is published where I have we have 100,000 copies which are published, and basically giving one copy to the public library doesn't make a big difference in the whole calculation of the publisher. However, if the whole edition just amounts to less than 100 copies, if every book is very expensive because it might be some art catalog with lots of color pictures and so on, where basically the catalog costs 200 euros per copy, then it's too burdensome for the publisher to have to provide a free copy to the state library. So in cases where there's a disproportionality between the small number of books that are published and the production costs for each book, so if the number of copies is low and the production cost is high, then the legislature should compensate financially the publisher. So this would also fall into the first group. So basically, it falls into the first and the fourth group. This case. And now, if we look at all cases, these four categories amount to about 90% of the cases where the court uses balancing. The other 10%, most of these cases are cases of criminal law or criminal procedure law, and that's actually also all the cases of the South African Constitutional Court and the Canadian Supreme Court where they use balancing. These are also all cases which deal with criminal law and criminal procedure provisions, and there one can say, well, maybe in these cases the court, because usually people which are subject to criminal procedure, they are not well represented in the political process. So for this reason, the courts have a role to counterbalance these decisions. It's legitimate for courts to basically come into play here and play a role as a counterbalance in these decisions. And in all the other decisions, they exercise some kind of self-restraint. And for this reason, I come to the conclusion that courts don't really exercise judicial activism when they use proportionality. So if they want to hide political decisions, then there are other instruments, interpretation of the wording of a provision, which are much suited, which are much more effective in hiding judicial activism than the balancing stage of the proportionality test, which is too transparent, I think, in order to hide judicial activism. So that's the book in a nutshell. I thank you for your attention, and now I really look forward to the discussion.
Thank you very much, Professor Petersen, for a very clear and succinct exposition of the thesis in your book. Any questions from the floor? I do have questions, but maybe I should ask the audience. Okay, you want.
Just one question about how you quantify the code, the 450 cases. How do you do dissents in the judgment?
I only looked at the majority decision, so I didn't quote dissents, and I didn't look at whether there were actually dissents or not. Sometimes it's difficult, so the German court doesn't always publish dissents. The Canadian and the South African do, and there you have the individual judges. But in order for it to be comparable, I only looked at the majority decision.
Simon.
What was your definition of judicial activism, and how did your study, how was it going to identify instances where there was promotion of judicial activism?
Yeah, that's probably the most difficult question that that you have when you have this kind of project. I left out this part of the book a little bit because of for time constraint. What I basically did is, in the first chapter of the book, I developed a theory of legitimacy of constitutional review. Or develop. It's very it's basically very much inspired by John Hart Eli's account of democracy and distrust. Basically, my argument is that the function of courts is to correct market failures in the political process. So if there are certain things where the legislature, and for most decisions, a democratically elected legislature is the best institution to take decisions in the public interest, but there are instances where it's not the best institution because in some instances you have capture by certain interest groups, and others minority interests might not have been taken into account, and sometimes you have collusion on the part of the political parties. So I identified certain instances of political market failure, and my thesis was that, or is still, that basically where courts correct these political market failures, they don't engage in judicial activism, and where they go beyond that, that's basically judicial activism. Now, it's not a mathematical exercise now to say, okay, this falls, there's still some interpretation on my part. But basically, what I would say that the less restrictive means stage and also the four categories that I identified for the German court mostly fall into this correction category. So often you can say that less restrictive means or consistency are ways to identify what the true motive of the legislature is. Maybe they wanted to pursue certain special interests, or they wanted to disadvantage certain minorities, so that many of these arguments are actually ways of correcting market failures, and they wouldn't do it openly because they don't want to accuse the legislature openly of playing foul, and so they have developed these doctrinal tools in order to have other indications for it and to have it in a more technical legal language. But functionally, it's correcting political market failures. That's basically the concept that's behind.
Alex and then Johannes.
Thank you. Really interesting talk. I wanted to follow up on the point you made about how proportionality analysis wouldn't be a good choice if you were trying to develop a way to mask or hide more naked political motivation. But I wonder if you can expand maybe on what's the appeal then, because I was thinking, well, maybe there's actually some appeal in the transparency of it for that reason, tying back to the legitimacy point you made at the outset. So maybe the best strategy for a judge then in these circumstances is not to try to hide their politics in some other way, but to use proportionality analysis as a way of making it more rationalized and defensible, and that is a better tactic, let's say, if you're interested in protecting or enhancing the legitimacy of the court. So, lots of courts are very politicized. Not all of them use proportionality analysis, maybe those that use proportionality analysis find it attractive precisely because it's a way to defuse the politics of what they're doing. Does that make any sense?
I mean, why proportionality is attractive for courts? There's this article of Judd Matthews and Alex Stone-Sweet who say, and I think there's much to it, who say that basically it gives courts a flexible tool. It's a doctrinal tool, but it's still flexible enough to adjust to the circumstances of each individual case. I mean, the main counter model would be to have some conception of rights as trumps, where you interpret the scope of the right,
Yeah.
and create smaller rules, very much like the U.S. Supreme Court jurisprudence on the First Amendment. However, it's the problem that you run into there is that at some point when you create these precedents, that you see, okay, maybe on this situation, the precedent that we have created 10 years ago doesn't really fit, and so you always have to try to adjust these general rules to changing circumstances in a specific case. And that proportionality is a more open structure, because it doesn't bind the courts for future cases to the same extent. So I guess that's the attractiveness of proportionality. Another attractiveness is to include political considerations. I'm not so sure about that. I mean, courts will, when they act in a political way, and probably lots of what they are doing is in an unconscious way, and it's. I've never been a judge, so I can't really talk out of my own experience. But my suspicion is that it's more in an unconscious way, and it's not that I want to get to this result and how do I argue for it. But basically, the reasons for why you come to a decision might be very different from the reasons that you give in your judgment, especially if you have some political motivation. And that means I can also be political when I do interpretation. It's just that when I do interpretation, I don't give the real reasons. I say, well, you can interpret this law. You have to interpret it very literally, and literal is what I said is the interpretation of this of the statute. So there are different ways to find the result you want to get, depending on independent of your political motivation. For this reason,
I guess just to follow up, to use the American example, if the work is being done at the point where you're defining the scope, that might actually be much more, that might draw much more attention to the political decision of deciding what the right means. Whereas if you're doing the work in the proportionality analysis, it may actually sort of steer people's attention away from that kind of brute question. And so maybe more palatable as a result. That was my intuition.
So I would have, my counter argument would be, if we are interpreting constitutional provisions, that's what judges do, right? We can claim expertise in interpreting judicial decisions. When I'm balancing, proportionality, even in the German court that has applied it for the longest, it's a rather recent, it's a rather recent doctrinal tool, and so they are under more scrutiny with this rather odd and doctrinal tool than they are when they interpret decisions, and that's why they might feel more secure in the interpretation phase. So it's also my intuition that I got when I looked at the decision. So less in the Canadian and the South African case, but in the German case, when the German court really wants to take political decisions, I don't know whether they want to take political decisions, but my impression was where they really interpret constitutional provisions and say, well, this constitutional provision requires the legislature to do X, Y, or Z, then they go much further than in the proportionality stage. That's my. I didn't do it systematically for the book. It's just my intuition that I got from reading something on the side. But yeah, that's the intuition that I have.
Thanks, Niels. I've got a few questions. I'm trying to figure out what exactly they are. The underlying values or underlying issues that underline your questions is really where to draw the line for judicial power. Whether we frame it as proportionality, as whether be unreasonable or whatever. Ultimately, what we are trying to do is to try to draw a line, and then we try to justify it. So in that sense, it's following on what Simon said earlier, is the mere fact that you try to correct the political market failure doesn't really answer that question. It may, to some extent, provide the traditional justification why the judiciary, undemocratic, unelected, would be able to override a statute passed by a duly elected legislature. There's a traditional Marbury and Madison type, you are trying to justify the legitimacy. But it doesn't really answer the question. On the one hand, yes, the judiciary can strike down certain reverse onus provisions duly passed by Parliament, as in the Oates case. But why should the judiciary, in the name of correcting political failure, enter into issues whether same-sex marriage should be allowed, whether social welfare should be granted to a particular group, or restriction is unconstitutional? You can still say this is just correcting market failure, political market failure, but it doesn't really answer why judiciary should not go there and so on. So in one sense, we were just playing with those terms without really addressing the real issue. And then various things like competence, etc., that comes into play. That comes nearer, and it seems a more honest answer to what the court are doing. So that's part about judicial activism. There's another part about the proportionality, which again, that term has been used in a rather diffuse manner, and it has been used in a whole lot of contexts. And I'm not, but I think I'll go to that later.
So do you have another, maybe you could ask that question.
So the question really is, does the judicial activism, as you define, as just to correct political market failure, does it really answer the questions that lies behind your question?
So it's a very good point, and I already said that it's not a mathematical exercise, right? You can either look at the standards yourself and say, well, the court's function is to interpret the Constitution and to apply the Constitution, but as we know, courts have discretion. This doesn't really answer the question itself, and so I try to find an external standard. And you're totally right that there are still different difficult cases: same-sex marriage, social welfare, where with same-sex marriage, I would say, well, we probably have at least we have a minority, so this is a case of minority protection, where courts have some legitimacies to step in. With social welfare on the other side, there it's very difficult to argue that there are any political market failures with regard to social welfare. At least when the courts are, and that's what they are usually doing, at least when they're extending social welfare. There might be cases, but most of the time, and that's also where I would be critical of the German court. The German court has lots of decisions where they're extending social welfare benefits for the middle class, and that's that's not really the task of a court to extend social welfare benefits for the middle class. They don't do it via proportionality, though. So that's why I think you're right. It's still a vague and murky standard, but I think it nevertheless gives us some guidance and probably more than just saying, well, the task of courts is to interpret and to apply the Constitution. But yeah, I think there's not the magic formula which tells you, okay, if anybody had the magic formula to tell you, well, this is exactly the border to which court should go, and once they overstep that boundary, it's illegitimate judicial activism, then there wouldn't be so much discussion about the issue.
David.
This is a really interesting project you've taken on, and I think some of my question follows on what Simon and Johannes were posing. The smaller question is the idea of pegging judicial activism to political market failure. From a political science public choice point of view, one might look at politics and say it's all market failure in the sense that all preference aggregation mechanisms are profoundly flawed, and therefore any line that you draw between market failure and just run-of-the-mill market failure is a deeply arbitrary one, right? I mean, the public choice literature teaches us that we're lucky that we even have any kind of stable collective decision-making whatsoever, right? So that's a problem. On the one hand, that's a problem with pegging judicial activism to the idea of market failure. And then I think this is where this ties into Simon and Johannes' point, which is the problem you've got here, there's conceptualization and there's operationalization, right? Conceptualization is how are you going to define judicial activism, and then operationalization is once you've defined it, how can you turn that into something measurable in a quantitative way? I sympathize completely when you say this is not something that can be measured with mathematical precision. Whatever definition you might come up with, it's not going to be mathematically precise. But the problem is, I think, where Simon and Johannes are pushing back on, I think I'm pushing back on this too, is the initial conceptualization of judicial activism as being market failure. If we're not with you on what concept you should be trying to quantify, then it's sort of beside the point how you quantify that concept. An alternative approach, so one approach, the obvious approach is trying to delineate the relative spheres of responsibility of the legislature and the judiciary. I mean, that's obvious, but again, because it gets you into this perhaps intractable line drawing exercise, I don't know if you've considered other options such as tying the definition of judicial activism to, say, the competence of the institution. For example, legislatures are known, this is going directly into the process theory literature, John Hart Eli in the United States. Legislatures are good at fact-finding, courts are terrible at fact-finding, courts are good at principle-based reasoning, legislatures aren't so good at it, right? So one approach might be to say, rather than try to identify market failures and say this is where courts are not being activist, you could say where are courts competent, where are legislatures competent, and then there's a well-established literature to fall back on. Another approach might be, and I think this is also tricky, but maybe is a little less normative, to try to identify what the scope of discretion, what discretion has been reserved to the courts, and then ask yourself whether courts are acting within the zone of discretion that they have. I think that's potentially problematic, but it might be less problematic than tying yourself to market failure.
Very well taken. Points. On the point that representation as such is problematic as a concept, because we have the social choice literature that you mentioned. That tells us that there's not the one way to aggregate preferences. That probably you have to have a certain starting point. And my starting point was basically from a Schumpeterian type democracy theory. And if you don't buy into that, then of course that's already a problem into into that you might not buy the other arguments that I'm making subsequently. But I'm wondering whether there are other the competence point. I'm not sure whether this is precise enough. I mean, if you say, okay, courts have legislatures are better in fact-finding than courts are in fact-finding, the problem is maybe legislatures don't want to do a proper fact-finding. For example, if let's say there's a child rape case, the easy answer of the political class is let's raise the penalty for the rape of children or for rape in general. And the assumption behind is, well, this has more deterrence than anything else. And the question we would now ask: does raising penalties really have deterrence? But that's not asked, and it's not important for the legislature whether it really has deterrence. What is important is that the electorate thinks that it has deterrence, that there's that politicians show some action, and so basically the fact-finding part is not really important for the political process. Even though they have more resources, they might not have incentives to do proper fact-finding, and their courts are the more neutral actor. So that's how this point is problematic. The second about scopes of discretion, well, how do you define where the limits of discretion of judges are? I mean, that's the central question. My proposal was to get around it by looking at it in functional terms. It also has weaknesses, but I think every approach has certain weaknesses, and we could say, well, we despair and we don't want to say anything on the question, but I make an assumption as a starting point. Of course, you have to buy in a certain way into the starting point in order to follow me on the rest. However, even if you don't buy into my theory of what judicial activism is, I guess it's still an important observation to see that courts try to self-restrain themselves with regard to the last step of balancing. So that the German court tries to rationalize the last step, that the two other courts try to avoid the step, because even though you can use the less restrictive means stage and the rational connection stage also for implicit balancing, and you might hide some political considerations there, it's not as far-reaching as the final balancing stage. So even without a conception of judicial, or even if you don't buy my conception of judicial activism, one could at least see that courts at least try to signal self-restraint. And what you make of it, that's a different question, but at least there is an interesting observation that you have, even if you don't buy into my conception of judicial activism. So those are 2 points. I mean, it's a very valid point, but...
If I could have the privilege of asking just one final question, we could overrun by 5 minutes. Assuming that I accept your definition of judicial activism, I agree completely with you that the findings themselves are interesting. So the fact that Canadian and South African courts don't really rely on the last stage, and when German courts rely on the last stage, they don't really weigh incommensurable values. Those are very interesting findings. What I take issue is, however, the conclusion that courts exercise considerable self-restraint when they apply proportionality. But because when we say that they exercise self-restraint, this suggests that they have a choice. That there are a number of options in front of them, and they decide to go with the option which would intrude upon governmental decision-making less. It suggests that. And how do you draw that conclusion? Because It might well be that the cohort of cases that come before the courts so happen that they don't really allow for what you call judicial activism, but what they don't really call for weighing incommensurable values. So it might be that courts are not choosing to not rely on the balancing stage, but it's just that for the cohort of cases in front of them, they don't have to, or they don't have the room to. And so it would be problematic to then conclude that they're restrained, and as you suggest, they're restrained for institutional self-interest as well. That to me seems to be a leap.
Mm.
So
basically your argument is that I have a selection bias because I only look at the cases where the court actually declares a law inconsistent with the Constitution without looking at the pool of cases they are drawing from.
No. I don't think it's so much of a selection bias, but the fact that if you look at the reasoning, you're looking at the reasoning and say that, they don't rely on they don't rely on the balancing stage, or even when they rely on the balancing stage, in fact, they are only looking at the fit between measure and purpose. They're reallocating financial burden, so they don't really engage in weighing of incommensurable values. My question, my problem with that is that, well, you can't conclude from this that courts are restrained, because it might well be that in the cases in front of them, there's no need to weigh incommensurable values. That's why their reasoning would not have to be based on weighing of incommensurable values.
Mm. But the assumption then is that in the cases where they accept the law as constitutional,
Right.
That basically what I'm saying as well, that in these cases the court, assuming that they had a choice, they could have declared the law unconstitutional because it's disproportionate, and it's disproportionate by weighing incommensurable values. I mean, there's one interesting case in the German jurisprudence. It's probably the most it's a bit of the outlier in the German case law. And this is the so-called Crucifix case, where the German Constitutional Court had to decide whether having crucifixes at the walls of Bavarian classrooms violates the freedom of religion of people who don't believe, or who believe in something else than Christianity. And here the court said, well, this is a disproportionate violation of the freedom of religion of the non-believers, or the people of different faiths. And what they did, they engaged actually really here in a comparison of incommensurable values, and they doesn't fall into any of the four categories that I identified. It's not a criminal law, criminal procedure case. So it's the case I can't explain with my framework. However, this case led to a huge backlash in the public, also in the legal literature. Even though some people were, even though some people agreed with the result, they said, well, this is methodological. This is not sound what the court did, and it remained an outlier. So this was a case from 1995. It was the only case that the court took in this manner, and now this might be by accident, but it might also be that the court saw, and that's my interpretation, okay, we can't go that far, and we shouldn't engage in explicit balancing. So I can't really rule out that that what you say that there's something to it, but I would have said, if you have such a long history of diverse cases coming to the court, the German court can't really select the cases it decides. then you should have seen more of the other type of balancing. So they have decided several thousands of cases on individual rights jurisprudence, and that it would be quite extraordinary if it was purely by the cases coming to the court that this is just due to the selection of cases that they have. But you're right. I can't really prove the point.
I think one additional finding that would enhance your conclusion, would strengthen your argument, would be to look at the cases in which they didn't rely on balancing, but which, in fact, there is an inherent discretion for the court to decide the case on the balancing link in those cases. So that this would suggest that they had a choice to use balancing, but in fact they chose to resolve the case on other grounds.
I can't think from the top of my head of any of these cases, but that's a good idea. I think there are probably some.
Especially with the least restrictive means, whether use the least restrictive means or the balancing stage, or even the legitimate aim stage or the balancing stage. I think there's some discretion for the court to choose which stage to choose. Yeah. Please join me in thanking Professor Niels Pete. Thank you. Good luck with the research, and congratulations on this book again. I'm sure it'll be part of the staple on proportionality worldwide. Thank you. And thank you for coming all the way to Hong Kong.
Thank you, and thank you for this great discussion. So it was really it gave me some food for thought. So
thank you for participating. Thank you. Associate Dean in Research.